all my colleagues, a pleasure in welcoming them to our court.
We welcome your lordships and your ladyship.
Item 501.
This is an application which has been moved by the Election Commission of India. This is for a minor modification. The Lord had directed the data which was submitted before this honorable court by 2 orders in the sealed envelope. Because the impression perhaps was that one of the copy of that data is with commission, but which
Presume that you would have retained a copy of what you had submitted in the court.
It was supposed to be in seal covered, taking the information from the political party. So we just submitted as it is. We got Lord. So the entire data is with this honorable court.
So what we could do is, we will ask our office to scan and digitize the data which has been submitted to us. It might just take a day or so, I think, because they'll start doing it immediately.
That can be postponed, mothers. They're putting it up on the website then.
We'll say that as soon as the data which is available with us is scanned and digitized, that will be handed over to the originals will be returned to the Election Commission. And they will then immediately, they'll immediately upload.
That's fair enough.
There's no objection. Lordships indicated also on the last occasion.
Now, just one thing, who's appearing for the State Bank of India? Because in our judgment, we had directed disclosure specifically of all details of the bonds, including the purchaser, the amount, and the date of purchase. They have not disclosed the bond numbers because that had to be disclosed by the State Bank of India. Because if you see our judgment,
Chip's judgment is quite clear on that. All details.
so all details have to be furnished by the State Bank of India.
I am for the government.
And they had said in their own application that they have the bond numbers, etc. But they said that they were in 2 different silos.
That's right.
The SBI's application for extension was on the ground.
SBI is not a party. They were here because they moved an application.
Anyway, if they disclose the bond number, we have no problem with it.
Lordships may issue
That's
notice to SBI, Malak.
Yes.
Application
My lord, may I mention, my lord?
Lordships may issue notice to SBI, Malak.
No, that no.
I'm requesting the honorable court.
An application has been filed by the Election Commission of India seeking further directions.
Stop.
In the judgment, in the order of this court dated, what is it?
11th of March.
11 March 2024. This court had directed that the Election Commission of India, that ECI, shall upload on its website the data which was furnished to this court and which was being maintained in the custody of this court. While issuing this direction, the court had presumed that a copy of the data which was lodged before this court, before the registry of this court, would be available with the ECI. Mr. Amit Sharma, learned counsel appearing on behalf of ECI states that as a matter of fact, ECI did not retain any copy of the data which was collated by it, since it was being placed before this court in sealed custody. The request, therefore, of the ECI is that the data which has been filed in this court may be returned to it, so as to enable it to comply with the order of this court for uploading all the documents. Full stop. This request of the ECI has not been opposed either by Mr. Kapil Sibal or the senior counsel or Mr. Prashant Bhushan, the counsel. Mr. Vijay Hansaya will be yours. Full stop. We accordingly issue the following directions: (1) the Registrar Judicial of this court shall ensure that the data which has been filed by ECI in pursuance of the interim orders of this court is scanned and digitized. Full stop. Upon the process being complete, this may be preferably carried out during the course. It may be carried by during the course of the day tomorrow, by 5 p.m. tomorrow. Full stop. Once the above exercise is completed, the original shall be returned to Mr. Amit Sharma, then counsel appearing on behalf of the ECI. Full stop. ECI shall then upload the data on its website within a period of on or before day after that day after.
You know, a copy of the digitized may also be given, Lord, so it will not take time in.
A copy of the, yes, fair enough. A copy of the scanned and digitized files shall also be made available to Mr. Amit Sharma so as to obviate the replication of the process of scanning and digitization. So now we'll pass another order. We'll say,
Would your lordships consider issuing notice to SBI? They may have something to say.
why do we have to? They should be here when the matter is going on. If they're not
I'm
here, why-
sorry, my lord. Please. They filed an application which is disposed of. They are not parties.
But really speaking, we can take exception to what they have disclosed because they were duty bound.
I'm not appearing for SBI.
The way
Your
Court can pass an order.
Your lordships may hear. I'm not here, my lord, for political.
Correct.
What is the operative direction in clause?
My lord, may I mention, my lord?
Here it is.
Yeah,
It says
operate-
SBI shall submit details of the electoral bonds purchased since the interim order of the court dated 12th February till date to the ECI. The details shall include the date of the purchase of each electoral bond, the name of the purchaser of the bond, and the denomination of the electoral bond purchased. Shall include, it doesn't mean it will exclude. SBI.
Your lordship's
One-
order
hold on.
is clear. What your lordships meant, my lord.
Allow me, sir. Allow me. SBI shall submit the details of political parties which have received contributions to electoral bonds since the interim order of the court dated 12th April till the date of the ECI. SBI must disclose details of each electoral bond, details encashed by political parties, which shall include the date of the encashment and the denomination of the bond. So this is an inclusive order. It shall include all details.
Lord, so would your lordships see BNC? BNC.
And your lordship had
Your
said that
lordships,
the reason,
B and C of your lordship's original. I'm not appearing, I'm assisting.
The-
I feel, my lord, SBI needs to be.
The order of this court, the judgment of the Constitution bench required SBI to furnish to the ECI all details of the electoral bonds purchased and as the case may be purchased or as the case may be redeemed by political parties, including the date of purchase. What are the other?
yes,
Date of
Your
purchase.
lordships.
Name of
B and C
purchase.
For my satisfaction.
Name of purchaser, purchase which have received,
and the
and the
denomination.
denomination, date of purchase, name of
the name of the
purchaser and
purchaser.
denomination.
And the date of purchase stroke redemption. Full stop. It has been pointed out, it has been submitted that SBI has not disclosed the electoral bond
Number.
the electoral bond number. What is it called? Is it called the unique identification number or is it called the
Called the unique alphanumeric number on each bond.
the alphanumeric number of the electoral bonds? Full stop. The Solicitor General submits that since he is not appearing for the SBI, a notice may be issued to SBI. Full stop. We direct the registry to issue notice to SBI, returnable on Monday.
Fair
We'll
enough.
keep it on Monday.
Keep your flags.
A copy.
My lord, may I mention, my lord?
Mr. Agarwal, just a moment. Don't interfere.
Ji.
A copy of this order shall be forwarded by the Registrar Judicial on the Standing Counsel appearing for SBI.
May I request, my lord, one thing?
Mr. Kapoor. Sanjay
Kapoor.
Lord, may I request, your lordships are keeping this on Monday. We are guests among us. This mentioning can wait, my lord, till Monday. I hope, my lord, I can convey myself.
There we agree with us. There is something to be said for what the solicitor said.
Lord,
Mr. Agarwal, would you like to mention this on
Yeah,
Monday?
my lord, I sent yesterday one request to honorable lordship
Credit
for sumoto.
us with reading our files and correspondence both. Would you like to mention this on Monday, Mr. Agarwal?
But
But I would
that
request him to
lordship
mention
is
on
fully
Monday.
aware.
All of us will request him to
Yes,
mention
madam.
on Monday.
We join this.
Your lordship may
But we
permit
have
me to
an
file
item on this,
proper
Lord.
application. But I was not a party, my lord.
Please respect the sentiments of your colleagues.
All of us are jointly requesting you to mention on Monday.
Keep your guys.
Grateful, grateful.
It was always, I like what Mr. Parasaran argued in India, sir. I think Attorney General must be consistent in certain respects. So, but I'm not following the same line of reasoning, because since 1990, a lot of developments have taken place, both in law and in facts. I just want to flag about a couple of issues. I think we must go beyond the theory in Kesara that India cement is a typographical error. We must go beyond that theory. So we get stuck to the theory that there is the analytical focus gets also very narrow. We must go beyond the theory in Kesara. Second, the Union of India is really concerned with the appropriate reading of entries 54 in list 1 and 23 and 50 in list 2.
What is the second point, Mr. Attorney General? The Union of India is concerned. Interpretation of the.
So the Union of India is concerned only with the appropriate reading of entries 54 list 1 and entries 23 and 50 of list 2. I think that's going to be the focus ultimately as to how the court is going to resolve a deadlock that Kesaram has suggested in reading various entries. I call it a deadlock because you can always have an ingenious way of disagreeing with a precedent. So it's something very important to take note of. Well, I'm at that when I talk about indigenous.
Kesharam also says that correctly interpreted.
After proceeding on a typographical error, premise.
Yeah, if you leave out this typographical error, what India Cement really meant was this, and what India Cement really rules is this. So are you then arguing that if the interpretation of India Cement, which is adopted in Kesoram, is accepted, then India Cement is wrong? That will have to. That's a
No, I'm
logical
not saying.
consequence.
I don't need to go into that, delve into that aspect at all. I'm saying something else.
But you will logically have to say that because the interpretation of India Cement in Kesoram, then you will have to say is wrong.
That's right. But as the court goes into the real question of how do we read entries 23, 54, and 50, perhaps that issue may fade to the background. So that may not have any direct significance and relevance. So when I use a very indigenous way of disagreement, you ought to know that in US constitutional law, there's a very interesting metaphor in the context of precedent. So you disagree because a shipwreck, a standard shipwreck is used, and you call it a derelict in the stream of law. So something which is to be overruled is a derelict in the stream of law. I don't think India Cement is a derelict in the stream of law. It can't be treated like that. It's a very Therefore, we say we need special justifications when we disagree with an earlier precedent. The court is very careful about it. The court has crafted lots of doctrines and principles in looking at precedents and how do we look at them, overrule them, disagree, particularly where we have a court sitting in benches. So where it is not is a different principle altogether. We have all those principles of a faulty reasoning, unworkable standards, abandoned doctrines, or even outdated factual assumptions. These are well-settled principles when a court can disagree with an earlier precedent and say for the following reason. Therefore, special justifications come in. But the only concern why I said about this, the ingenious way of disagreeing, is a matter of concern in the realm of overruling a precedent. I just want to make that point. The court will tread very carefully when say that on such, it can't be even a principle, say typical as a principle, but I don't want to delve into it beyond a point. So, as I said, Union of India is concerned only with the correct interpretation, reading of entry, so and so. Having said that, I think the key to understanding entry 50 is to look at two expressions which are stated in entry 50. One is mineral rights and the other is taxes on mineral rights. Both are composite expression, but taxes on mineral rights contains the expression mineral rights. So unless we unlock the meaning of these two expressions, then probably we'll have a circular reasoning. And that's what happened in India Civils. You wanted to have a concept of a tax on mineral rights, and they have an opposing principle, therefore tax versus tax. So royalty as a tax. Therefore, the important is understanding what is mineral rights and what are taxes on mineral rights. It's also important to bear in mind that post-constitution, the paradigm shift in the whole mineral rights regime, ownership, nationalization, so on and so forth. So when you had only one regime where a private owner can exploit a mineral right on any terms whatsoever, and the state entering in saying that I will nationalize. So all those things are very important for the purpose of understanding a post-constitutional entry 50 construction. Because I find that about in the past 20 years, almost 110 nations, I have placed on record a World Bank study on mineral rights, taxation on mineral rights, etc., across the globe. I'm not going to read that in extenso. I just want to flag a couple of things which are present in this study. The word tax is also used interchangeably with royalty. But about 110 nations have replayed their mining law or altered their mining law or brought in a new mining law. And today in a globalized situation, when a lot of mining operations take place across the globe, it's not merely no longer a local domestic mining industry engagement. Therefore, the fiscal impositions which a central law may conceive of and devise, and how it can probably occupy a field available to states to legislate. So if you get stuck to a fossilized state, namely the mineral rights could be either the ownership on minerals or activities on minerals, and taxes on mineral rights must have a certain meaning which can never be altered in context and circumstances, would be a probably inapposite way of looking at the whole constitutional scheme. It is in that context, I think we need to look at whether the state owns minerals or a private party owns minerals. In the right to part with in any manner, the right to part with in any manner, and to deal with minerals.
The formulation, Mr.
I have my written submission, but I'm trying to just give a bullet point so that I try to, before I read my written submission, I have. So the right to part with in any manner and to deal with minerals, or the subject We can probably do this.
If you see entry 23 of list 2 and entry 50 of list 2, then we'll go to list 1. Let's see the distinction between entry 23 of list 2 and entry 50 of list 2.
Lordship, please.
Entry 23 says regulation of mines and mineral development.
Yes.
Subject to the provisions of list 1 with respect to regulation and development
under the control of the union.
Now let's see 50 for a moment.
54.
Taxes, sorry, 50.
50.
50. So of the same list.
Taxes on mineral rights, subject to any limitations imposed by Parliament by law relating to mineral development.
So there are two critical differences. 50 speaks of limitations. So there have to be limitations. Second, the limitations have to be under a law enacted by Parliament. Third, the law must relate to mineral development. Now, look at entry 23 on the other hand.
Yes.
The field of Parliament is much broader in entry 23 than in entry 50. Just now let's see entry 23 again. It says regulation of mines and mineral development. Now it doesn't say subject to the provisions of a law. It says subject to the provisions of list 1. Right? Yes. Then it says list 1 with respect to what? Unlike entry 50, which says by law relating to mineral development, it says with respect to regulation and development under the control of the union. One option would be to say that that part with respect to regulation and development by the union must be also confined to mines. Right? It may not be so. The field for Parliament under entry 23 is much broader. Now, if you go, for instance, to list 1.
Entry 50, 54 of list 1.
Right.
The parliamentary field.
Right, parliamentary.
Yes, it's very wide.
See, for instance, 53. 54 says regulation of mines and mineral development to the extent to which such regulation and development under the control of the union is declared by Parliament by law to be expedient in the public interest. So, what is brought in entry 50, imposed by Parliament by law, the reference to parliamentary law in the case of entry is found in entry 54.
That's right.
It is not provided by entry 23. Entry 23 merely says the provisions of list 1 with respect to regulation and development under the control of the union. This may include entry 53. It may also include 54. Not just 54, because 53 says regulation and development of oil fields and mineral resources, petroleum and petroleum products, other liquid substances declared by law to be inflammable. So entry 53 does not merely comprehend entry 54 of list 1. Entry 23 of list 2 does not only comprehend entry 54 of list 1, but it may comprehend other entries in list 1. That's one aspect. Second, more importantly, for our purposes, entry 50 of list 2 uses the expression subject to such limitations. Unlike entry 23 of list 2, entry 23, the entirety is made subject to list 1 with respect to regulation and development.
That's right.
Entry 50 does not subordinate the taxing power of the states with respect to mineral rights to the entirety of list 1. It subordinates it only if and to the extent to which there are limitations which are imposed by Parliament. So whereas in the case of regulation and development of mines, the entire area of regulation and development of mines is subject to the provisions of List 1 pertaining to regulation and development. The subordination of the taxing power of the states in relation to mineral rights is much less. That subordination arises only when there is a law enacted by Parliament and that law prescribes limitations. That's the distinction.
We try to look at it. That's a very important question.
And that has to be a law. And my sister Justice Nagaratna says very correctly that that law has to be relating to mineral development. In 23, it's a law relating to regulation and development.
No,
23.
Let me try to look at it like this a lot.
As would be covered by the latter part of entry 50, namely a law relating to mineral development.
So one way of looking at it is to look at all these entries as one family, one composite family. The underlying thrust is regulation of mines and mineral development. So if that underlying thrust, that area, that domain is made over to Parliament under entries 53 and 54, probably we will not nibble out one part of it. And therefore say that small area alone or aspect alone will be a limitation. The moment we do that kind of a dissection, then the parliamentary scope of parliamentary legislation entry 53 and 54, then one can ask a question, why is it that entry 50 is subject to a certain limitation? So if it is simply taxes on mineral rights, it would have been a free area for the states to legislate. The moment it is subject to certain other aspect or a domain or a regime, then will it be possible for the court or somebody to argue that we will look at it very narrowly? While the federal structure issue is important, certainly yes, but what is important is the parliamentary domain in regulating mineral development in the larger public interest. Therefore, the larger public interest today is to be seen in a globalized situation. It can't be in a very domestic sense pre-1948 era. Therefore, before I go through my written submission,
Mr. Attorney General, what happens?
Yeah, Lord.
Once Parliament makes a declaration under entry 54 of List 1, right? In respect of the area covered by that declaration, it is completely then abstracted, as Mr. Dwivedi said, or excluded from the state list.
He said that, yes.
The moment Parliament makes a declaration under entry 54 of List 1, that area goes out of the legislative field of the states. But that is not in relation to the taxing power which is given to the state under entry, the taxing field, not the power, because power is Article 245. That is not in respect to the taxing field which is given to the states under entry 23, because it's a limitation on the taxing power. It's not an exclusion of the taxing power. Unlike 23 of List 2, the moment Parliament makes a declaration by law under entry 54 of List 1, to that extent, it is excluded from the power of the states, right? In respect of the taxing power which is given or recognized in entry in entry 53 of 50 of List 2, what Parliament can do is impose restraints. But Parliament can't say that, well, we have the power to impose the tax, you don't have the power to impose the tax. The power to impose the tax is not given to Parliament at all. It is only given to the state. But in the interest of mineral development, Parliament can say you will not tax in this manner. For instance, your tax should not, just an example, it should not exceed 20%. Or Because, if you put the tax in a certain way, it might impede mineral development. But the taxing power always remains with the state in relation to mineral rights. That critical distinction we have to understand, that this is not a power given to the union at all. Because, and one more reason, the areas where the states have taxing powers is very limited under our constitution. Most of the taxes are given to the union. The states have very few areas of taxation. And liquor, for instance. Therefore, those areas we must not dilute. That's, of course, one more reason.
I quite see all that. I mean, the very important aspect, dots which will probably connect with a final understanding of how do you look at the entry. I certainly agree with that. But suppose I look at it from 2 points, 2 alternate theories on how you look at entry 50. Before I come to that, I thought let me quickly make a few or 2 or 3 points in that context and come back to addressing this issue. I thought all activities in relation to minerals will form part of mineral because we are looking at entry 50.
All activities,
all
no,
activities
I didn't get the point.
in relation to minerals
Yes.
will form part of mineral rights. And these are from the birth and completion of mineral activities. I'm not looking at the ownership of mineral rights per se. I'm not looking at that for the time being. Because if it's ownership embedded, unexploited, nothing follows from that. It remains as part of the land. But its mineral wealth, I think, is expected to be exploited. I don't keep a gold mine without exploiting it. So it has to be exploited. Therefore, unexploited mineral wealth probably will make no sense or relevance in the context of any one of the entries. So from the birth and completion of all mineral activities will be the conspectors of mineral rights. Can do his written submission. And bullet points I have. I'll just hand it over, but before I read my written submission.
We'll see how you formulated that. Will, I think, help us.
I thought before I read them, kind of a summary of those submissions trying to. Yes, sir. So Harish. Yeah.
No, but somebody impose a tax on mineral rights. Somebody must have put in.
Probably more than one way of looking at it, to give an answer.
If you it has to be yes or no. Yeah, I mean, are you contending that Parliament can impose a tax on mineral rights?
What did the constitution makers conceive of and talk of taxes on mineral rights? So we have to answer that question. It must be in relation to mineral activities.
But if Parliament can impose a tax on mineral rights, then which is the source? Which is the legislative?
We say Parliament, by a literal reading of entry 50, does not have the power to tax mineral rights. By literal reading. But unless we understand why mineral rights and the competent tax mineral rights form part of an entry, unless we understand that.
So we take it that it is your case that Union Legislature can frame a law imposing taxes on the area covered by Article 50, Item 50. Is that your case?
Let me try to expand that.
Right.
I'm trying to build a foundation for explaining why entry 50 may need an entirely different way of looking at it.
We are looking at list 2.
Yes.
And we are seeing that the state is empowered under
Yes.
list 2 to impose tax. For you to say that, I do not know whether that's what you are trying to say, that the union will have the power there on tax element. We are not talking about mineral development. It's a little difficult for us, I mean, unless you are able to sort of tell us why it is to be understood in that fashion.
Well, let me try to proceed a little further. I mean, one was trying to look at what will the entry 50 look at it today. How will it look at it today?
One way of looking at it is, if the state wants to impose a tax on mineral rights, then first it has to see whether there is any central law regarding a limitation on mineral development, not on anything else. It has to look to the central
right.
law.
That's right.
If there is a limitation made by the parliament on the particular aspect of mineral development, keeping that in mind, the state will have to impose a tax or an impost. So that is the way, because the second part of entry 50 is subject to any law made by parliament which acts as a limitation in the context of mineral development. And in all these three entries, whether it is entry 54 of list 1, entry 23 of list 2, or entry 50 of list 2, mineral development is common.
That's right.
Which is actually a subject made over to the parliament in the interest of uniformity and development for a national or a public interest. So that should be the way in which a state should proceed before imposing any tax on mineral rights.
I'm thankful for that way of looking at it. So I ask myself a question again. If on a literal reading, Parliament does not have the power to tax mineral rights, how do you read the second part of entry 50? Limitations on such taxing powers. So it is a non-taxing power limitation? That would not make any sense. So it has to be a power which is equivalent to it, or comes closer to saying, whatever authority you may have to impose a particular tax, in the context of mineral rights activities, if Parliament has occupied that field, and any charge, any levy, any impost, which Parliament would therefore engraft into such law, would be a limitation. One way of looking at it.
Legislative field of Parliament cannot be traced to an entry in list 2. A legislative field for Parliament has to be only founded in an entry in list 1.
That is true. But then, therefore, I said 54, 23, 50, in a way, look at them as one family of entries. If you look at them in isolation and unconnected entries, because forgetting for a minute, they are in list 1, list 2. Forgetting for a minute. Therefore, if entry 50, the second part of entry 50, must receive a relevant meaning,
You have repeatedly said that entries in list 1 and 2 form part of the same family. Is that really correct?
I want to advance.
There's a dividing line.
Yeah, in a way it would be correct because
It is mutually exclusive.
we can't, in where there is a, for instance, in several entries in the Constitution, particularly in list 2, it says subject to. That's a very standard way of putting it. But here it's not merely subject to. So in a sense, limitations that a parliamentary law can bring in. And if we say that the parliament will not have any power to intrude into a taxing domain of the legislature at all, state at all, then this is written off. This part of the entry is virtually written off. So therefore, you may have to, it is not like any other corpus of entries in the 7th schedule. We have the education rights, entry 64, 65, subject, etc. We have certain other entries subject to list, entries in list 1. They all stand on a different footing. So therefore, when I say it's a family of entries, for the purpose of understanding entry 50, we have to look at it. Not that one entry 53, 54 will probably take away some power under entry 50 or 23 in list 2. I'm not suggesting that. But if you read entry 50 in its plenitude, it suggests that Parliament in its domain of mineral development law, whichever way you look at it, it could be a regulatory law, it could be a law only relating to mineral development. In its parliamentary wisdom, it can have any such law. It suggests such a law can be made. If that can be made, what kind of limitation?
But yes, exactly.
Yes.
Law for what?
I come with that. So if the law in relation to mineral development is not like saying how will you lay your mining plan or where can you extract your minerals. We have several legislation in relation to mining today. So it's not really related to mineral development in that physical sense. It's in the larger sense of national public interest, of conservation. That's why Section 18 of the MMD Act talks about mineral development. Perhaps one can look at it a little beyond that also. So if the law relating to mineral development, which means mineral activities, insofar as it says, I would require people who participate in mineral rights activities to be subject to the following regime or stipulations. That's will be one set of limitations. That's why I thought when looking at 50 from more a historical point of view and also protecting the federal principle, the balance, etc. So I think some riddle that has to be opened here. So it can't be opened perhaps on a mere literal reading of any of these entries. Therefore, what troubled me while reading entry 50 also was, if at that point of time, when the Constitution was enacted, if we still talked about taxes on mineral rights, I tried to look at where did in Government of India Act 1935, you have the same entry. So what is the origin of all this? Mineral rights. I couldn't really locate even from any English precedent or any statute, but in 1900s, England had something called a duty on mineral rights. That's where I find an isolated reference to mineral rights. But for our purposes, under Indian legal framework, MMRD Act, the 1948 legislation, it's a state which dictates how will you undertake a mineral development activity. How will you deal with your mineral wealth? Who will deal with in what manner? Subject to what conditions? So lease is one principle, a well-settled principle, but engrafted into a statute. So these are those principles which go into both entry 53 and 54 law in relation to mineral development. If you keep all those broad features in mind, and then jump into entry 50, and you find if somebody were to read it saying limitations on mineral development, will have a very narrow scope in the sense, on the first hand, I will rule out by a little reading that Parliament does not have a right to tax minerals at all or mineral rights.
No,
Yeah, sorry.
see, I mean, you are speaking for the union.
I'm speaking for the union.
Your views are very crucial.
Yes.
Now, we have a situation of the state under list 2 having the power to impose taxes on mineral rights subject to what is there in list 154, right? Now, can there be, we are trying to test it on an extreme basis. Can the Union of India make a law that the state will not tax mineral rights?
It can in any given. It can.
So your answer is that
let me
Union of
try to
India
explain.
can make a law?
It can. That's why, therefore,
No, it's a very extreme thing. Suppose such a law is made,
Yes.
then what happens to one of the practically very few sources of revenue to be earned by the state, and they are expected to also discharge certain obligations in the federal.
That concern is certainly an important concern. I mean, it can't be just relegated to lack of importance. But if that logic were to be pressed into service for the purpose of understanding entry 50, we directly encounter a problem, which means that the domain of states to earn revenues, entry 56 is one such domain. There are other domains.
Certainly.
Today, for instance, even under Section 9B of the MMRD Act, all district development mining fund, it goes to the states. More than 60,000 crores goes to the states today.
No, the union will extract and then pass it on to state is one thing, and state imposing the tax itself.
You lost right. Therefore, when the union does what the state can otherwise do, the state need not worry about it. The state need not say my power is being taken away. Your worry will be when
the concept of federalism, which is a very fundamental feature of our
entry 50 is also part of the federal structure. If entry 50, then the second part of entry 50 will be scissored off. Then we are looking at entry 53 and 54. They're significant, they're important about mineral development from a larger national perspective. That becomes little narrowly tailored. It's very important. I'm not trying to belittle and say, look here, just read down the state's legislative authority to, levy or import taxes, etc. I'm not saying that. But it's a general principle one can say in a different context, yes. But in the context of entry 50, it takes a different connotation altogether.
So your contention is that limitations will include prohibition. That's your contention.
No, I'll come to that. In several situations, for instance, under Article 19, 2 to 6, restrictions will not include prohibitions. Regulation will also include prohibitions. But instead of going to that very difficult area, let me put it like that, because the court will have to balance many things there. The union says regulation includes prohibition. Sometimes it can be problematic. I understand that. But I'm trying to navigate a slight middle path saying that shall we not give entry 50 that meaning which the constitution makers thought it must have? And now as we move in point of time with mineral development, and mineral development be the key to looking at 53, 54, 23, and ultimately entry 50. So the court will keep that in mind. So
if we give it
before that, no, I'm sorry.
If we say in terms of an example, let us say the central government wants to encourage development of granite. So they will say instead of a 20-year lease at a time, we will grant 30 years. So that is an aspect in the interest of mineral development.
Right.
And the states want to tax on granite. They will say, since we have given now in the interest of mineral development from 20 years to 30 years to encourage granite as a mineral, we will say for the first 5 years of the lease period, there shall be no tax on granite. So that will be a limitation on the state's power to tax on granite.
That's true. In a way, hints toward.
Because it is in the interest of mineral development.
Yes, that's right.
So that is a limitation which the parliament can make. And then the state cannot tax for the first 5 years of the lease.
That's right.
And it is in the interest of mineral.
Absolutely, absolutely.
The power of the state to tax doesn't get whittled down.
No, I'm not saying it will be whittled down. It will be, I don't say to write it off completely. I'm not saying that. In Hinstone, this court came closer saying regulation means what? Prohibition. I'll place that judgment. But I don't want to suggest that the doors of the taxing power of the state should be completely closed. Entry 50 itself doesn't suggest that.
Mr. Attorney General, there are many actors here. Mr. Dwivedi,
yes,
Mr. Salve, the solicitor, but you are the protagonist. You are speaking for the union as the Attorney General.
That is true.
So we expect you to sort of, whatever you are saying, obviously with a sense of responsibility you are saying.
Absolutely.
But we are trying to test the proposition that you are canvassing before us. Are we, by virtue of what you are trying to say,
yes,
diluting or taking away
I'm
power of
I'm not suggesting that at all.
tax. Sorry?
It's a diluted policy.
No, it's
I'm not-
diluted certainly, but
Entry 50 itself,
totally
there is a
take it
dilution.
away.
I say entry 50 itself is a dilution.
1919, Your Lordship.
So I'm not saying that, the one has to look at the law. We are not talking in the abstract. I'm saying basic, certain abstract principle, then let us look at the law. If the law occupies the field, it's a limitation, then a court on a factual or a evaluation or analysis of a law will reach conclusions either way. I am not trying to look at any of the legislations now. My job is only to present the broader constitutional picture. I am not getting into that at all. Because I see many of the legislations, I think the Madhya Pradesh and the Chhattisgarh legislation talk about a particular percentage as value of the mineral wealth extracted. So that's a different issue altogether. But we're only looking at this entries. I mean, why did constitution makers thought that there'll be, therefore, what is this mineral right we are talking about and what kind of taxes? So let me now take your lordship through my written submission. But what is troubling is, if you look at the word tax from a very conventional point of view, that's why I think in India's events, the only way of resolving it was tax versus tax. So I don't think that would be one way of resolving this issue. So the taxes on mineral rights will have to be given a contemporary mineral industry development perspective. So taxes on mineral rights will have to get their contemporary meaning. And that will be essentially linked with mineral development. So if it is merely a levy or a charge on a piece of land owning mineral wealth, then it will be directly on the land question.
Mr. Attorney General, before you read your submission, I was just doing this over the last 5 minutes. If you look at list 2, list 2 uses different mantras. I've actually identified 1, 2, 3, 4, 5, 6, 7, 8 different mantras which list 2 uses. The first mantra is subject to list. An entry in list 2 says it is subject to an entry in list 1. That's the first mantra.
Right.
And you can take down the entries.
Yes, yes.
Entries 11, earlier entry, 11, 17, 22, 24, and 60.
That's right.
These
are subject to.
That is, it is subject to an entry in list 1.
List 1.
That's the first mantra. Just to give you again, 11, 17, 22, 24, and 60. Right? So clear subordination of a list 2 entry to a list 1 entry. Second, the second mantra which list 2 uses is other than.
That is entry 32.
Now there are 3. Entry 12,
yes,
32, and 63. What is the meaning of other than? Completely taken out of the state list. All right? Abstracted. That's the second mantra. The third is subject to list 1 and list 3.
Yes.
Entries in list 1 and list 3. There's only one entry like that, entry 13.
right.
Entry 13. Subject to list 1 and list 3 entries. That is entry 13. The fourth mantra is subject to a list 3 entry. Subject to list 3 entries. And there are 3 items in that. Entry 26, 27, and 57. The fifth is subject to a particular field, not a particular entry. That is entry 23 of list 2. Entry 23 of list 2 doesn't refer to any particular entry in list 1, but it refers to a field of regulation and
right.
development of mines.
That's right.
That's number 5. 6. Subject to the provisions of any law made by Parliament. Any law made by Parliament. Look at entry 37 for a moment of list. It's a standalone entry. Elections to the legislature of the state subject to the provisions of any law made by Parliament. That's the 6th mantra which has been used in list 2. The 7th is subject to the limitations imposed by Parliament by law relating to mineral development. It is our entry, entry 50. That's the 7th. And the final mantra is not including, which is used by entry 54 now as it stands. Entry 54 was substituted after the GST amendment took place.
That's right.
And now it says, but not including sale in the course of interstate trade on commerce. So other than and not including would have broadly the same meaning. When they use the word other than or not including, means that is outside the fold. So these are basically the 8. 1, 2, 3, 4, 5, 6, 7, 8. 8 formulations which list 2 has made. Now, where Parliament wanted a subordination of the state power completely, it has subordinated by saying subject to. If it wanted an exclusion of the state power on a particular area, they have used specific words, other than, not including. Where the Parliament wanted the power of the state to be restricted, we find that restriction is where it is subject to a particular field, that is entry 23. Where Parliament contemplated a restriction, a limitation, that is entry that is entry 50. So when in the same list, the framers of the Constitution adopted different formulations and phrases, we cannot attribute to the use of the phrase in entry 50, limitations imposed by law, a meaning which would amount to subject to or other than or excluding. So we have to be careful that while interpreting entry 50, we don't attribute to Parliament what would otherwise be achieved by words such as subject to, other than, excluding. The Constitution could have used those phrases here in entry 50, but it yet used no, subject to what? Limitations imposed by law. If they had said other than, then conceivably Parliament could have taxed mineral rights under which entry? Entry 97.
Your Lordship, right.
Because then mineral rights say in respect of major minerals. If they had said taxes on mineral rights excepting major minerals, and there was no specific entry in list 1, Parliament could then tax under entry 97. Right?
I feel.
But they have not done that. They have given the entirety area of taxation of mineral rights exclusively to the state.
Taxation cannot be in two subjects.
And taxation cannot, yes, right.
Taxation cannot be in two lists. See, in addition to what Honorable Chief Justice said,
indebted to your Lordship is.
Please see entry.
But let me try to connect. I'm sorry. Let me try to connect. But all this distribution of entry, the way they overlap or they don't, exclusiveness, etc., will ultimately depend on the competence principle, one. So what is Parliament competent to do? What is the state legislature competent to do? That principle is an underlying principle. And when it says subject to so and so, the competence principle is assumed. Now, laws made by Parliament, it's also assumed that Parliament cannot make a law which it is not otherwise competent to make a law under in list 1. So that competence principle is the underlying thread. So if that is the underlying thread, the degrees of exclusion, nature of exclusion, what kind of exclusion can take place are all found in these differing methods of the ways parliamentary lists have been sought to be related to. I think that's how one will look at it. But having said that, if you remove the word limitations in entry 50, so we are trying to look at it in a scientific, like a laboratory experiment. We remove the word limitations. So tax on mineral rights, subject to law paid by Parliament and mineral development. So it means Parliament could have made any law touching upon taxes which legislatures or state can make. So if there is an added significance with the word limitation can lend to entry 50, so that's added significance can be in the context of taxes. So therefore, a subject of taxes, namely a charge or a levy, which may otherwise form part of a parliamentary law, will be treated as a limitation on the taxing powers of the state legislature. Therefore, it implies two things. Parliament has a competence under 53 and 54, And that law can also have something to say about the taxing powers. If it is not, the limitation does not make any sense.
So then they could have said subject to entry 54 list 1 straight away. But they don't say that.
They need not say.
It is subject to any limitations.
Your Lordship, 53 and 54 need not say that at all. Therefore, when that competence, that overarching competence,
In a tax.
we are trying to, yeah.
3.
Yes.
The subject education is in entry 25 list 3. It says subject to list entry 66 list 1.
63, 64, 65.
Therefore, the field is, if it is occupied under list 1, then under list 3, the state is denuded of its power. Entry.
That's very true. Very true. Therefore, we are in the
Now
dynamic.
use the expression subject to entry.
That's why, because we have to now look at how Parliament will enact the current law. I'm sorry.
What you see, power of taxation has to be
Yes.
that you interpret the entry in a particular, of course, it's a very broad field. You interpret the entry in a specific manner and also confer the power of taxation.
Very
Power of taxation has to be conferred.
Absolutely. I'm not.
It can't be a matter of interpretation.
I'm not suggesting anything which runs aground of all these principles. I'm not suggesting anything.
No, your submission, I was just looking at your written submission. You talk about the proper and correct interpretation of these entries. Now, if we are looking at proper and correct interpretation of these entries, so far as the union is concerned, in the mineral development field, it does not confer a power of taxation.
It need not. It need not. Let me put it in more. Therefore, the moment it says it is brought into entry.
We have disturbed you too much.
No.
Should be permitting. I'm sorry.
I think what we'll do, Mr. AG, is I think we can first look at your 7 propositions, and then we look at your written submissions.
Yes.
That will.
Before the 7
Should we just run through the
one?
7 written propositions so that we'll understand your propositions?
My written submission?
No, these 7 propositions.
Yes.
Yeah, because we haven't completed reading that.
Yes.
We can read with item serial number 1 also, because.
I just flagged it. That's all.
Should we read it together, Mr.
I'm
AG?
not spending my time on that item.
Should we just read through it together, Mr. AG? Should we read through it together, the 7 propositions, so that you'll.
I was at proposition number 5.
5.
All activities in relation to minerals will form part of mineral rights. And these are from the birth and completion of mineral activities. Then 6, any levies or demands or exactions in relation to these activities are taxes on mineral rights. The word tax here does not connote any other special meaning. It means any charge. Last, to the extent MMDRDA provides in respect of all or any of the mineral rights activities, and also in relation to charges or demands in respect thereof, it covers the field of taxes on mineral rights, keeping in mind proposition number 6 stated above. Because there's something like an ID fix tax, therefore in India, we had that clashes of tax principles. So unless I say royalty is a tax, I'm not getting into a point. So I don't want to spend time on India 7th how it got resolved.
Apart from royalty, does the MMDR impose any other tax?
No, there's
a
for instance, under section 9B, now there is a district development, mining development fund. And there is also 9C, there is a district mineral trust. So there are a lot of ways and means by which Parliament looks into generation of revenues which are shared.
6620.
entirely goes to states. GST share.
9B.
They
Your written submission.
Yes, it is volume 2D. I don't propose to engage in reading India Simmons and Kesaram and before I take your lordship, so that in fact yesterday question fell about impose, what does it mean, etc. I placed on record in volume 4G an interesting article on the historical, it is volume 4G.
You like to sort of take us through your submission
I'll do
because, then we'll try and understand it.
I'll do.
The following core issues.
The following core issues arise for consideration in the light of the questions which have been referred by the reference court in so and so. What is the true construction of entry 50 list 2 in the company of entry 54 list 1? And having regard to the special and peculiar features of the mines and minerals industry, where the words and expressions used in entry 54 list 1 and entry 50 list 2 will receive their special meaning as may be in consonance with the conjunction of the above said entries. B. For the purpose of understanding and arriving at a true construction of entry 50, we need to look at the words and expressions occurring in entry 50, their technical connotation and their logical nexus. The laws relating to mines and mineral development, whether the Mines and Mineral Development Regulation Act 48 or 57, are based on long established principles and understandings. The grant of permission to undertake any activity in relation to a mineral is a core aspect. The grant of such permission, called the lease or license, is always based on certain terms and conditions. The consideration for the grant of such permission, traditionally known as royalty, is in essence a demand for parting with the privilege of working the mineral. Such a consideration is also in essence the price to be paid by the recipient of the permission for working the mineral. Working the mineral includes several activities such as exploring, winning, producing, processing, transportation, or dispatch, and sale, as the case may be. All these activities, either under a lease or otherwise, will be mineral rights activities. The bundle of mineral rights will come into being on the grant of such a permission of parting with a privilege. Mere ownership of a land with mineral wealth by any person is not by itself a mineral right within the meaning of entry 50 list 2. Consequently, any and all levies, charges, imposts, or demands that can be imposed on or demanded from will constitute taxes on mineral rights. It may also be seen that MMDR Act 1957 has enacted in Section 19 the prospecting licenses and the mining leases to be void if in contravention of the MMDR Act 1957. This would mean that all mineral rights activity will be regulated under the MMDR Act of 57. The regulatory scope of MMDR Act is wide. In a connected context, in the state of Tamil Nadu with Hindstone, this Honorable Court has proposed that the word regulation in relation to this law will be read widely. Next, the interplay between 54 and 50. For the correct purpose of entry 50 list 2, the word taxes need not be seen from the point of view of conventional connotation. For the purpose of entry 50 list 2, taxes shall be taken to mean any compulsory exaction, levy, charge, impost or demand that may be charged in relation to or in respect of mineral rights. It has to be in relation to or in respect of mineral rights. Now, next, both entry 54 list 1 and entry 50 list 2 constitute, as I said, a family of entries. Both the entries have in mind the principle of mineral development and all attendant and related activities that will connect to mineral development and in promotion of mineral development. Taxes on mineral rights must be understood as such as levies, charges, impositions or demand that are related to mineral development and not otherwise. So mere presence of mineral wealth and not mineral rights. Rights in relation to the exploitation or working of mines or minerals are mineral rights. The concept of mineral rights is understood in England its own so, as evidenced by the Finance Act 1910, where under Section 20 thereof, a duty on mineral rights was imposed on the rights to work minerals. I said beyond that, I was not able to locate anything else. Taxes on mineral rights cannot be any levy, charge, impose or demand unrelated to mineral development or only with reference to the it should be ideal existence and availability of mineral wealth. Please correct it there. So in other words, entry 50 list 2 cannot be the source of authority for imposing any levy, charge, impose or demand, which is either unconnected with mineral development or in relation to any other alien purpose, such as an education cess. Entry 50 list 2 is not an entry conferring competence on the state legislature to convert it into a general taxing purpose entry. Entry 54 list 1 contemplates complete legislation in relation to the regulation of mines and mineral development and all incidents of mineral development. The concept of regulation occurring in entry 54 list 1 is a comprehensive concept. Mineral development means it includes all activities and transactions in relation to the availability and the working of mines. Consequently, the processes and the procedures that will be required for providing in respect of such activities and transactions would be an essential part of such a law. As stated above, the process by which the right to win or extract or to work minerals is on the basis of a lease or a license, as the case may be. All matters relating to such leases or licenses would form part of such a regulatory law. Further, the charge which can be demanded or the consideration to be parted with in relation to the grant of leases or licenses would also be part of such a law. In other words, all matters relating to mineral rights and mineral development will fall within the scope of entry 54 so providing in regard to mineral development. I'm talking about section 18. I'll come back to it later. The next paragraph. A levy, a charge, impose or demand part for parting with the right to win, extract, work, etc. always carries the expression royalty. As already stated above, since a mere ownership of mineral cannot be the reason for imposition of any levy, charge, impose or demand, any imposition in the hands of the state has to be in relation to mineral rights. It is in this context that the expression taxes occurring in entry 50 list 2 will have to be understood. This expression shall be taken to mean any levy, charge, imposition or demand that can have a nexus with mineral rights activities. Beyond this, the word taxes in entry 50 list 2 cannot have any other general meaning or connotation. Since entry 54 list 1, law being a regulatory law, insofar as such a law deals with all matters of levies, charges, imposed or demands that can be legitimately provided for having a nexus with the mineral rights, such matters of levies, charges, imposed or demands will be treated as a limitation on the power of the state to demand or impose similar levies, charges, impose or demands of the same nature. I think that's the crux of entry 50. Once the word taxes occurring in entry 50 list 2 is seen from the above perspective, there'll be no further need to inquire as to whether entry 54 law is a law under a taxing entry or not. To reiterate, merely because the word tax is used in entry 50 list 2, the law relating to mineral development, in order to be considered a limitation, with the meaning of entry 50 list 2, need not be necessarily a law under any taxing entry. So comparison with general and taxing entries in the general scheme of the 7th schedule may therefore be opposite. Reliance Place and MPV Sundaramaya is also in opposite in that context. Then attempt has been made in India 7 to suggest that the cess in question under section 115 of the Madras Village Panchayat Act cannot be a levy in relation to land. And if it is the nature of a tax falling in entry 50 list 2, it will fall foul of MMDR Act 1957, which provides in relation to royalty. It was in that context the proposition that royalty is a tax was pressed into service to exclude from entry 50 list 2 the cess in question. It is submitted that this understanding has arisen out of a misconception about entry 54 list 1 and entry 50 list 2. And that's one way of looking at India Simmons. Then it's submitted that for the purpose of delineating the limitations on tax on mineral rights in entry 50 list 2, it is not one, that the taxes which can be levied by the state under entry 50 list 2 will be under other than levies, charges, imposed or demands falling outside the well understood categories of levies, charges, imposed or demand in relation to mineral development. 2, the taxes which can be so levied need not partake the character or features of royalty and such related demands. 3, that any levy, charge, impose or demand that may form part of the law relating to mineral development, if and insofar they are in relation to mineral rights, will be a limitation noticed in entry 50 list 2. Further, in the above view of the matter, it's immaterial that royalty is designated as a tax or not, as long as taxes on mineral rights, by whatever name called, namely levy, charge, impose or demand, can be only in relation to mineral development or mineral rights facilitation, mineral rights facilitation. Similar levy, charge, impose or demand are provided for and enacted in entry 54 list law 1. That will be relevant for the purpose of entry 50 list 2. In the light of these submissions, Kesaram indices needs to be clarified. Therefore, there is no need for the court to embark on an inquiry as to whether India Cement suffers from a typographical error. Then, next paragraph. Any levy, charge, impose or demand with reference to the value of a mineral produce from a mineral bearing land or with reference to any other aspect of the mineral will be treated as a levy, charge, impose or demand in relation to mineral rights activities. They cannot be taxes falling under entry 49 list 2. In consonance with the principle that taxing entry cannot be enlarged, lands and buildings occurring in entry 49 list 2 cannot include in any matter in relation to mineral rights activities. It is reiterated that the entry 54 list 1 enables the parliament to enact an all-comprehensive legislation in relation to mineral development. Mineral development, as stated above, will necessarily include and relate to mineral rights. Matters relating to the grant of mineral rights would thus include a levy, charge, impose or demand that can be imposed in relation to the exercise of mineral rights. The constitution makers did not contemplate that a law under entry 54 list 1 will not deal with matters relating to levy, charge, impose or demand in relation to the exercise of mineral rights. A law minus these aspects will be neither a regulatory law nor a law in relation to mineral development in all its aspects. Consequently, the Constitution did not envisage the need for a separate entry in list 1 under which a law relating to levies, charges, imposed or demands can be enacted. A law under entry 54 list 1 enacted with all such elements and providing in regard to all such aspects will not only be a law that will impinge under entry 23 list 2, but also be a law that can be treated as a limitation under entry 50 list 2. On the entry 54 list 1 law being a complete code, see paragraph so and so in Monetarist part and Sandur Manganese. The predecessor legislation of the Andhra Pradesh Mining Mineral Bearing Lands Act 2005, namely the AP Act of 1975, was struck down by the Andhra Pradesh High Court in KCP Limited. The High Court has considered both India Cement and Kesaram. The 2005 Act is a virtual reenactment of 1975 Act and stands enacted in the strength of Kesaram. I'm not getting into those aspects, just want to flag it. That's all. For Your Lordship's information that as an appendix, we have placed both judgments and dictionary meanings of these
Let's go
words,
through.
levy.
Let's run through it, Mr. Attorney.
Very.
These 2 pages.
Page 11. Levy means to realize or to collect. Only necessary conditions proceeding for realization of the fine must be commenced within stipulated period. Levy includes proceedings for assessment. It not only includes number 8, not only the imposition of the charge, but also the whole process up to the raising of the demand. The term levy is wider in its import than the term assessment. It may include both imposition as well as assessment. Then 10, levy can also mean the act of raising money or men. 11, the term levy, it is held, is an expression of wide import. It includes both imposition of a tax as well as its quantification and assessment. Then 12, the term levy appears to be wider in its import than the term assessment. It may include both imposition of a tax as well as an assessment. The term imposition is generally used for the levy of a tax or duty by a legislative provisions indicating the subject matter of the tax and the rates at which it is to be taxed. The term assessment is also generally used in the country for the actual procedure adopted fixing the liability to pay a tax. Then number 13, the expression levy may include both the process of taxation as well as the determination of the amount of tax or duty. Collection refers to actual collection, etc. Then imposed. Imposed means a compulsory levy. Tax in its wider sense includes all imposts, and it can be vice versa. So imposed next means a compulsory levy. The well-known and well-settled characteristic of tax in its wider sense includes imposed in the context of following characteristics: the power to tax an incident of sovereignty, law in the context of Article 265 means an act of legislature. Then 3, tax under Article 265, read with 366/28 includes imposts of every kind, namely tax, duty, cess, or fees. And 4, as an incident of sovereignty and the nature of compulsory exaction, a liability founded on principle of contract cannot be a tax. The technical says an impost, then local special. Then 16, impost means any tax or a tribute imposed by any authority, particularly by a tax or a duty laid by government on goods imported. And duty means the duty of customs. That's where in several foreign customs duty, the impost carries a particular special meaning. Then I don't think any trouble you'll have further with reading the duty.
Actually, Mr. Attorney General, paras 17 and 20 of your submissions, they really are the key, the soul of the submission. Let's just see paras 17 again and 20. Just
Duty
small
means
paras.
my written submission?
Yeah.
Anyway, I'll come back.
Paras 17 at page
I'll just
8. Duty is okay. I mean, in the above view of the matter, it is immaterial that royalty is designated as a tax or not, as long as taxes on mineral rights by whatever name called, namely levy, charge, impost, or demand, can be only in relation to mineral development or mineral rights facilitation. Now what follows is important. Similar levy, charge, impost, or demand as provided for...
And enacted in entry 54 list 1 law. That will be relevant for the purpose of entry.
So you are really reading the power to tax in entry 54 of list 1 itself. Yes. And second is para 20, where you again, let's see para 20 for a second.
Yes, it's reiterated that entry 54 list 1 enables the parliament to enact an all comprehensive legislation in relation to mineral development. And mineral development, as stated above, will necessarily include and relate to mineral rights. Matters relating to the grant of mineral rights would thus include a levy or a charge or impose or a demand that can be imposed in relation to the exercise of mineral rights. The constitution makers did not contemplate that a law under entry 54 list 1 will not deal with matters relating to levy, charge, impose or demand in relation to the exercise of mineral rights. A law minus these aspects will neither be a regulatory law nor a law in relation to mineral development in all its aspects. can say that. Have you seen well, the bench is now sitting out the line?
Thank you so much. We've got the submission.
Yeah, only one. In the timelines for arguments, it is that attorney will take 2 days. I think that's a typographical error.
There, everybody will agree.
That's well put, Mr. Attorney. That's really well put.
I'm grateful for
Thank you, Mr. Attorney. Sorry?
Yes.
Yeah, please.
No, no, you go this. Not picking up where the early left. There are two important questions, Your Lordship, are pleased to put to my mind.
Questions were volume 2D, no? I just forgot to make.
2D.
I'll just digress from where I was
No, 2D. hai.
and address one very important question which has been troubling the court. Because that's really the heart of the matter. The attorney has submitted, Your Lordships are pleased to notice that the union has, in a larger sense of the word, a taxing power on the entry 54.
That we have not clarified.
I leave that to one side.
Hearing for,
I appear for Eastern Zone Mining Association for Tatas. I'll give my number. CA 1883 of 2006 and some other matter. 1883 of 2006. I want to start pick up the thread by flagging two important points. Our founding fathers knew that in the 1935 Act, it was not in the devolution list of 1919, but in the 1935 Act, a notion of taxes of mineral rights had been created. And it had similarly been made subject to limitations. And I'll be showing all this. Let me just tell my lord what I'm driving at. Our founding fathers knew that there is a thick black line between taxing powers and regulatory powers. And Sundaramaya has never been doubted. And as my lord the Chief Justice, in fact, on one reading picked up, there are so many different models. But let's look at the model in 50 itself. And that is why in my submission, this is sua generis. So there's nothing else like this. And my lord, there has been some, if I may say so with great respect, perhaps misunderstanding of what our position is. There is no denudation of power in 50. Let's be clear. Denudation is of the regulatory power of 23 because of the declaration in the MMDR Act.
can you just take that again? The denudation
is, my lord, in entry 23 power or the field.
Right.
Yes.
There is no overlapping tax power in our two entries. My lord, we once came very close to this in the luxury tax cases, as they were called, my lord, the hotel receipts tax case, where the aspect theory got injected. And fortunately, it was given a healthy burial in the Godfrey Philip case. Unlike the Canadian Constitution, we divided our legislative fields neatly, cleanly, acknowledged where there is overlap, and that is why 246(1) says notwithstanding and 246(3) says subject to. And tax entries were compartmentalized. And a very good example of that is entry 84, the excise duty. Union list excise duty on everything other than alcohol for human consumption. State list originally excise duty on alcohol for human consumption. So our tax lists are neatly divided. Knowing all this, the founding fathers said, a tax on mineral rights subject to limitations imposed by Parliament, first of all. It's the only entry in which Parliament limits a taxing power of the state. And those words have to be given a meaning. And how are these limitations to be found? Imposed by Parliament by law relating to mineral development. And my Lord, respectfully adopting what the Attorney General has argued, this phrase, law relating to mineral development, must, like all legislative entries, be construed in its plenity. A rather narrow view of this, saying there must be a section in the MMRD Act saying you will not impose a tax, or you will not impose a tax more than so much, is perhaps too narrow a view of the Constitution. So we do not need to say if something goes out of 50, where does it land in entry in list 1? No, it doesn't. And why was this done? Justice, those very important point my Lord was pleased to ask was Mr. Palkhiwala used a very interesting expression in this courtroom. The resources of a state are niggardly compared to that of the union. When we were, my Lord, arguing that the union tax on hotel receipts was unconstitutional, the state tax was valid. Never forgotten the expression, niggardly resources of the state. My Lord, there was one problem with mineral rights. And this is a serious problem in the federation. Our mineral resources are not evenly endowed. Some states are much richer in mineral resources than others. And yet, the economic development of each state has compelling need for minerals. North India are not so rich in other things, doesn't have minerals. Central India in Maharashtra, we used to have coal to a small extent near my hometown, but not much. Now, Malad, look at Orissa, look at West Bengal. God has been, they have abundant resources. Karnataka, great amount. You go further down to Kerala, you find nothing. So, Malad, nature, when God created land, Malad, He didn't draw these boundaries, He have drawn these lines. So, not all states are equal in resources, and this in the past, Malad, has been the cause for great friction between kingdoms. So, the framers, right from 1935, when the Government of India Act first recognized this, it said provincial government may impose mineral tax subject to limitations imposed by the federal government. This has been a matter of grave concern always. And this whole matter has to be viewed in that context. As I said yesterday, Malad, ultimately it's a question of seeing the balance between entry 50, entry 23, and entry 54. And as far as 23 and 54 is concerned, Malad, I don't have to reinvent the wheel. Right from Hingir Rampur, Bajnath Kedia, Talak, they have all explained how these two laws sit with each other, and I'll be taking a lordship through those 3 or 4 cases. And as I have in my opening indicated yesterday, what did we argue in India Cements? And this has troubled the court, Malad, be it the Patna judgment, be it the Mysore judgment. If you have excessive royalty, one state is rich in a particular resource, it has a very high rate of royalty. There are industries in another state which require them mineral. You're creating economic stress. So Parliament says you will not have more than so much royalty. And very interesting, My learned friend argued yesterday, Parliament can't usurp the power. You're right. 9 doesn't usurp the power to royalty. 9 says, you, the state, recover this royalty, but not more than so much. So the resource remains with the state. It doesn't become a union resource. Now, if Parliament says you should not have more than 50 rupees per ton, I'm just taking an arbitrary figure, of royalty, or 5,000 rupees a ton of royalty on, say, iron ore, you say, all right, I have 5,000 rupees a ton of royalty, and then I have 300% tax on mineral rights to extract that royalty. The limitation on 9 is meaningless. And that's one of the crucial passages in India Cement about, are you not indirectly increasing royalty? You are negating the limitation imposed by Parliament on royalty. And some of the laws, I'll show you, Lordship, state tax on royalty.
By doing what?
Suppose we say 300% tax on royalty paid. You say 30%, you say 300%, you say whatever percent. So I am allowed royalty of 1,000 rupees a ton, I take that, and then I have 300% tax on that, so 3,000 rupees by way of tax.
But Parliament can still enact a law that your rate of taxation shall not include this gap.
But is 9 not that law, is the point. And that is what India Cement looked at. When you see the conspect.
Actually is not a restraint on tax because royalty is not tax. I think we have all very
It doesn't
clear
need to be.
that royalty is not tax. In which case, the cap which Parliament imposes under 9 is a cap on royalty and not a cap on tax.
I'm sorry.
But even today, Parliament can come out with a simple law saying that, look, we don't want any state to have taxation of more than, say, 12% or 28% on royalty.
Your Lordship has
to absolutely do it as a
Lord, of course, it does not 9 fulfill, is the point which your Lordship
That's the heart of it, really.
And I'll tell my Lord, there's a whole analysis which is underlying this submission. Yes, my Lord, prima facie, it does look that Parliament should say you can't have so much tax. But there are so many different models of tax. So if Parliament fixes an exaction, is not royalty an exaction, my Lord, I'm not using the word tax. Because the basic difference which came in India is because of how the English altered land tenures in India.
Section 9, which provides for royalty rates or cap, is an exaction which has been imposed.
It's an exaction. And tax on mineral right is also an exaction, albeit in the form of a tax. The difference on tax on mineral rights and royalty will be, and I made bold to say so, where the state is not the owner of the mineral. And we still have some small areas where some minor minerals don't belong to the state. The state has nothing to do with the minor mineral or the mineral. Mr. A, a private person, is exploiting the mineral. He's not even giving a lease. He's digging up his own ground and taking out mineral. You can say, all right, I tax you on this, on your exercising your mineral rights to extract. Or A gives the lease to B. As we have so many cases, not decided by your lordships, decided by high courts. State can say, I'm not exacting anything, I'm imposing a tax on mineral rights. Now, where the state itself is the owner of the resource vested in it for public good. We have now long abandoned the theory that the state is like any private owner. That ship sailed long ago. Your lordships were not in RNRL and Reliance went to the extent and say these are all these, the mineral wealth is held in trust. And that is why these elaborate provisions. And once your lordships see, my lord, the current trend of the legislation on how auctions are held, how prices are fixed, it's a complete fit. Now,
Mr. Zavri, you're saying where the state is the owner of a resource,
owner of the mineral,
vested for public good.
vested for public good, it is all, royalty itself becomes the exaction. And if you say no more than this, then you can't sidestep that. Then that itself is the limitation. And this is never going to happen to major minerals, but maybe in minor minerals. We have seen some of the minor minerals are decontrolled. The state says, all right, you let the private people deal with them. The moment that happens, the legal character changes. And Parliament may not want to limit that. If Parliament says no more than this much tax, then public or private, that tax is frozen. Because, my lord, please see what a question which my lords have asked 3 times, and the answer lies in the question. It has to be as a facet of mineral development. The limitation must not be, I don't like your face. I don't want you to burden poor industrials. It has to be as a facet of mineral development. That's very important. That's in 50 itself. You can't generally limit as a resource limitation. It has to come as an integral part of a law which limits mineral development. How will that come? If it was, my lord, a general, in fact, as my lord the Chief Justice pointed out, some entry says subject to a law made by Parliament. Not any kind of law. Parliament can make any law and knock you out. But, my lord, when 50 says by law relating to mineral development, that means the limitation must be an integral aspect of mineral development. So when we see all this,
Yes.
that is how your lordships will have to look at it. So, my lord, to get to this, and that is what, my lord, how our submissions are treated in your lordship's judgment is another matter. It's put in 2 sentences in India Cements. You cannot do indirectly increase royalty. This was the submission. And the submission, my lord, actually, since I have only less time today, let me just digress. The submission about the contradiction, as I said yesterday, my lord, had nothing to do. The judgment is dealing with 2 completely different points. Justice Vanchu's dissent in English, and I'm going to read that to you. The majority, as we say so in all humility, my lord, was clearly right. They said a tax on mineral produced, the quantity of mineral produced is a measure, the tax is on mineral rights. He said, no, the moment you put it with reference to mineral produce, it becomes an excise duty. So it's unconstitutional. And the next sentence he says that royalty can be a tax on mineral rights. But royalty itself is with reference to mineral produced. What it was saying is, if that is so, then royalty is not a tax on mineral rights. If something with reference to mineral produce is an excise duty, it doesn't metamorphosize when you call it royalty. I mean, it's either excise, it's wrong to say it's excise. With great respect, the majority didn't accept that. And nobody has ever even ventured that line of reasoning here. But you can't in the one breath say, if a state imposes a tax on production, it's an excise, but a royalty on production is a tax on mineral rights. That was the little mismatch. And that is why in that sentence they say, previous para and this, that therefore a tax is not a royalty. But what was the view which they accepted, Manoj? The Mysore judgment said royalty is an exaction. And that clearly is, and I'm going to show my lord the provisions of the Act. Royalty is an exaction, and it has become more so, if I may say so with respect, my lord, after the 2015 amendments. The auction rules and this and that, how the whole MMDR Act now works after your lordship's judgment in the coal matters and all, saying, please, these are national resources. Their mode of disposal has to be completely transparent. And maximum revenue for the state. Now, when you make a law for maximum revenue from the state, and the state auctions and gets as much as it can out of this resource. And which is what is good, because that money is going to go back into the coffers of public good. And then you say now you can ramp it up more through mineral rights. It's not going to work because there is a limitation. Private rights, yes, please tax them. Your own public rights. When there is an elaborate mechanism created for you to harness these rights, you cannot go beyond. That is really the principle. So that was the Mysore test. That was the Patna test. This is an exaction already. In that sense, royalty is akin to a tax. Now that becomes, the shorthand becomes royalty is a tax. And the moment you say royalty is a tax, you say, hold on a minute. Royalty is the price of the mineral, it's not a tax. And then you say, oh, somebody got it really wrong. But if you look at it this way in its larger context, that royalty is an exaction of by the state in respect of its mineral wealth. And when Parliament has come up with a complete code on how that wealth is to be harnessed, is that not a limitation on the tax and mineral rights? That's the real issue. Lordship may say yes, your Lordship may say no, but let's at least be clear. That's the issue.
Mr. Salve, you talked about mineral wealth and how it is unevenly distributed all across various states in the country.
Yes.
You also talked about perhaps hinting at the generational exploitation aspect, meaning thereby the limitation on the exploitation of mineral wealth. If this generation exhausts, extract the entire thing, a particular state is going about whatever is available, extracts. To put a cap on the quantum, we talked about only the price element. To put a cap on the quantum, that could be a limitation.
Also
pertaining to mineral rights.
Entry 23. That
Entry 23. Yes. But of course, you have said it in your opening, you cannot denude the right of the state.
You are not denuding. As I said, the trouble is, we try to fit this in a pigeonhole. 50 stands by itself. Denudation, occupied field, and repugnancy. There are three well-known constitutional concepts. But we should not try and squeeze 50 into any one of these. It can be a different kind. There is no, as my Lord the Chief Justice pointed out, there is no other entry like this, subject to limitations imposed by Parliament. This entry stands on its own. So, my Lord, to say that therefore this is a kind of denudation, why do we need to put a label on it? This is not a denudation. You have the power. My Lord, tomorrow, if there is a private lease and if you're going to decentralize or denationalize minor minerals, the power comes back in its plenitude if you take it out of the MMDRA. So, that power is not taken away. It's a specific pinpointed limitation by Parliament. What I am saying, and the only point of difference really is, I say when the phrase is by a law relating to mineral development, anything which is integral to mineral development becomes a cap on a taxing power. Why? Because the Constitution says. So no use going back to Sundaramaya. Sundaramaya was not dealing with an entry like this. In fact, again, not respectfully borrowing from what the attorney said, this is a peculiar family, mineral rights. And it has its history. It is rooted in history. And it is not perhaps instructive, and it will be of assistance to your lordships to see that history. How did this evolve? The legislative history of this matter starts with the Government of India Act. The first one, the 1915 Act, and they're all on your lordships' bundles. Let me get on quickly. Volume 4A. Solicitor is not here. But actually, I forgot to mention, solicitor was to follow, but very kindly, my lord, I requested him and he allowed me because I want to finish by Wednesday.
Very quietly slipped into your timeline also, Mr. Salve.
No, my lord, yesterday itself I had said I need 2 days. Yesterday I got about half an hour. Today I was just picking up the threads. Once, back in the day, we were not so pressed for time. My lord. Somebody asked Mr. R.K. Garg, the late redoubtable R.K. Garg, how long will you take? It depends how long you take to understand. He was known for his repartee.
Unique ability. He would speak and then he would look at the back as well, you know. You were very young
Yeah.
lawyers and you would make a point and then look
around.
Look around.
Whether it had the requisite
See,
impact.
Formidable impact on ahead of him and behind him as well.
Yeah. I think once, I think it was Mr. Justice Hidayatullah, one of the judges got who didn't like his brusque style. Mr. Garg was a very staunch leftist and he got arrested for some protest or something. And he was brought. And then next day he came into court. As he got up, the lights went out. So the angry judge said, Mr. Garg, it's very difficult when you argue, don't throw light, but today you're throwing darkness. Well, if your lordship turns to volume 4A,
Yes.
page 27. I won't read it, my lord, but
4A27 is that history of Professor C.L. Anand's book
yes,
title, right?
yes, ma'am. It begins at page 28. I won't read it, my lord, tempting as it is, because it's a very romantic start to how all this started, the preamble. The way it worked, my lord, section 45. What page is it? Pages are all gone again.
Where will we get section?
Yes, my lord, section, yes.
It's 44. Page 44.
It's page 44, I think. Yes.
I'm checking.
And if your lordship is pleased to see, just to get the link. So relations, I'm sorry. This is the relations of local government to Governor General and Council. So there was clear subordinate, it was subordinated. It will have some relevance when I come to it later. And the division is in 45A. First of all, provision may be made under the rules for the classification of subjects in relation to the functions of the government as central and provincial subjects for the purpose of distinguishing the functions of local government and local legislatures and from the functions of the Governor General and Council. And then, my lord, 65, section 65, bring the page. Actually, I'm sorry, my lord, please see first 52, the Indian legislature. It speaks of the two chambers. In fact, it's interesting, my lord, the two expressions used. Council of States and Legislative Assembly. We borrowed the expression but used them differently. And 63B is Legislative Assembly and 65 is powers of the Indian legislature. Page 55. it went more on the basis of Indian legislature has power to make laws for all persons, all courts, all places, things within so and so on for all subjects of His Majesty, etc., etc. And the actual split, Marat, came through the rules, because they said by rules you may do it, and we had the devolution rules, which came under the earlier provision I showed 45A. And the devolution rules is in volume 4A. Sorry, 4F. Page 14. Your Lordships have bundle 4F. Yes. I have this. Rule 3 said, for the purpose of distinguishing functions of local governments, local legislature, and from the functions of the Governor General and Council and Indian legislature, subjects shall be classified in relation to function as central and provincial subjects in accordance with the list in Schedule 1. So this is the first time, Malad, where we started dividing legislative fields. And page 24, I'm sorry, page.
They were mutually exclusive. So
Yes.
it was included in provincial subjects set out in part 2. It shall, to the extent of such inclusion, be excluded from any central subject.
This is the first experiment with defining legislative fields. And Malad, the legislative fields your Lordship get at page 24. There was something with mines here. One, these are very, very short lists. 19 was somewhat similar to our industries list, and 20.
Section 4 talks about settlement of doubts there itself.
There's the Governor General, he was the boss. Whatever he said would prevail. Page 25, if your Lordship is pleased to see. There are two important entries. This is the genesis of this declare by law that was declared by Governor General and Council. Entry 20, development of industries in cases where such development by a central authority is declared by order of the Governor General in Council expedient in public interest. And my lord, our mining entry is 25, and please see the language was much narrower. Control of mineral development, insofar as such control is reserved to the Governor General and Council under rule made or sanctioned by the Secretary of State and regulation of mines. And then the residuary was 45. All other matters other than expressly accepted, and all not including. In the provincial subjects, entry 8 was land revenue, so that was a taxing entry. Then, my lord, entry 16 at page page 28. Excise, that is to say, control over production, manufacture, transport, etc., etc. 24 is very interesting, man. Development of mineral resources which are government property. Why it came this way, Manoj, I will not take time now, because when I read the 2 or 3 judgments on land tenures, how the land tenures evolved is discussed in those cases. So we have allowed entry 24, development of mineral resources, and 25, subject to rules made or sanctioned by the Secretary of State, but not including regulation of mines. And then industrial matters, including the following heads, that's one of the industries. Then entry 47 was provision of sources of provincial revenue not included in previous heads, whether taxes included in scheduled taxes, scheduled not included in the schedule, etc., etc. So this was not the spread.
There were no separate taxing entries.
No, Manat, it was more like resources. Yes. Page 39, Manat, they, in the scheduled taxes under section 88, which came later, but page 38, if your lordship has it. For the first time, they inserted this. Your lordship has it, page 38. Put to the page. Scheduled taxes rules. Because, my lord, this was separately given to the states by the Governor General in Council. And your lordship sees, again, this was done in the Legislative Council of a province may, without the previous sanction, take into one consideration tax imposing so and so. And Council of a Legislative Council may, without the previous sanction, take into consideration law imposing authorizing local authority to impose tax in 2. Then the Governor General and Council may, by order, in addition to those in 1 and 2, to these rules. And nothing will affect rule of a local authority. Now, Schedule 1. Please mark item 1, Manoj. A tax on land put to uses other than agriculture. And in Schedule 2, we have a tax on land or land values.
Where do we get that? Land and land values, yes.
And perhaps the reason was that at that time, my lord, this is 1919, we had multiple land tenures in play. There were large areas of mines which were privately owned. And that's the problem with the Murthy judge. If land includes minerals, as I indicated yesterday, there are 2 arguments which your lordship will have to consider. One is the pure legislative argument saying if there is a specific tax on a species of land, can you also read it into another engine, which is not subject to limitations? That's one thing which is wrong with Murthy judge. But the second is also wrong, Malad. Post 1950, in any event, after the entire Zamindari abolition happened, invariably, in all the land reform laws, mineral rights were given to the state. Now, if I do not have the right to a mineral, how can it be taxed? How can the value of the mineral be a legitimate measure for taxing me on land? If you have a tax on vehicles and I don't own a car, can you say the annual value of a car will be the tax you pay on a scooter? That won't be a legitimate measure. The way Murthy looked at it is, mineral rights are only a measure. You can't have a measure unrelated to the subject of the tax. Now, if mineral rights are part, one can understand saying, okay, I'm taxing a part of the land. But if mineral rights are not there, they can't be a measure. And that is why, my lord, because by the time our constitution, 35 Act itself, started making these differences, because by which time a lot of the mineral wealth, partly, my lord, as your lordship will find in the judgment, because when the British started granting zamindari, and World War I, World War II times, they realized we need coal. I mean, the war machine needed coal. They needed iron ore. So they started taking the mineral rights away. So 35 Act recast this completely. The 35 Act, and I'll try and finish that today, is in volume 4. This is, my lord, in volume 4, page 545. There are various provisions, my lord, which give a broad idea. I put them in my submissions. But let me come straight to the one which is relevant. Page 593. Section 99. Subject to the provisions of this Act, the federal legislature may make laws, including laws having extraterritorial operation, for the whole or any part of the Dominion, and a provincial legislature may make laws for the province or any part thereof. Subsection 2, without prejudice to the generality of the powers conferred in the preceding subsection, no federal law shall, on the ground that it will have extraterritorial, then, my lord, we leave that. 100 is where we have R240, old 246 comes from 100. Notwithstanding anything in the next two succeeding subsections, the federal legislature and a provincial legislature has not power to make laws with respect to any of the matters enumerated in list 1 of the 7th schedule of this Act, hereinafter called the Federal Legislative List. Then 2 is the concurrent list, notwithstanding anything in the next, the federal legislature, and subject to the preceding subsection, a provisional legislature shall have power to make laws with respect to the matters enumerated in list 3, and subject to the preceding subsections, the provincial legislature has, and the federal legislature has not, the power to make laws for a province or any part thereof in the matters enumerated and so on. So the federal legislature has power to make laws with respect to matters enumerated in the provincial legislature list, except for any province or part thereof. The section 100 divide was in the 7th schedule. There also it was the 7th schedule, and that you'll also find at 735.
Page 735.
Yes. No? In the first list, at 737, one minute, please. We have entry 36. language almost similar because we have now removed oil fields and put it in a separate entry. Regulation of mines and oil fields and mineral development.
Mr. Salve, which is the entry that you are?
I'm so sorry, 36, my lord, page 737.
Yes.
Regulation of mines and oil fields. My lord, what we now have removed oil fields and put it in entry 53 of list 1. Because there is no equivalent in the state. Oil field is completely taken out now. Regulation of mines and oil fields and mineral development. In fact, if one was to run a blue pencil through the word and oil fields, then the words would be exactly the same as now. Regulation of mines and mineral development, to which such regulation and development under the dominion control is declared by federal law to be expedient in the public interest. The words there were to which such regulation and development under the dominion control is declared. We have used language which would have almost the same effect. The state list, and again, there's no taxing entry in list 1 on mineral rights. List 2 begins at page 738. And the relevant entry is entry 23, 739. Regulation of mines and oil fields and mineral development, subject to the provisions of list 1 with respect to regulation and development under dominion control. So one of this is echoed in R23 in language which is almost the same. And finally, Manoj, page 740, the 3 entries. I can close there today. 39, land revenue. 42, tax on land and buildings, hearths and windows. Very interesting. Thank God we dropped hearths and windows, otherwise we would have gone the Dutch way. And 44, taxes on mineral rights, subject to any limitations by any act of the federal legislature relating to mineral development. Yes, page 74. I'm sorry, Manoj, page 740. So there is no taxing entry in list 1, but list 2 has a limitation. Now, with this history, Manoj, I will place for your Lordship's consideration certain relevant provisions. My friend Mr. Dwivedi has very helpfully shown most of them of the MMDR Act, and then Malot cite the 4 cases so that we don't need to reinvent the wheel. Malot, a lot of this law is already settled by constitution benches. Continue on Tuesday.
Mr. Salve, we'll try and complete your submissions by Tuesday. By Tuesday, Mr. Salve.
Tuesday won't be. Because there's a lot of ground to cover.
We were thinking that between Tuesday and Wednesday, at least this side should be completed.
I think that we should be. I'll try and finish. The solicitor is yet.
The solicitor has to argue. So if you can conclude maybe in an hour or
Thursday, the oversight.
Tuesday and Wednesday, because we don't have a,
Thursday will be miscellaneous day.
because Thursday is miscellaneous. So if this side can conclude on,
not.
in the 2 days.
It will not be possible, very realistically.
If the point is of such,
Oil industry, we haven't started. Our entry is different, our legislation is different.
my lord, there, I think the attorney is also there. My lord, there is one intervention about whether GST can be charged on royalty. Now, that's a
That's not-
completely
That's not
separate
that
kettle of fish.
Yes.
That's not that clear.
That is not the subject matter there, Shanis.
Jurisprudence.
The whole jurisprudence is different.
Would be different.
And one small,
Different or not, that will be seen when the matter comes up.
I just want to make a note of it. Volume 3D, the Union has filed an affidavit where it gives information about the mineral rights available in various states
Yes,
and the royalty which is, the learned
I'm
person will
going to
address
take
all
it,
that.
sir.
That's a very
I have a
important.
separate set of arguments. Not that, my lord, I will be repeating,
Lots of.
We'll start on
except
Tuesday.
not some inevitable way.
We'll resume on Tuesday.
Tuesday. Lots of.
On what, to my mind, were the 8 key points that he has articulated in his piece. And those points are: 1, the greatest challenges can be solved not by fighting with each other, but by acting together. 2, technology gives us the means to address problems on a humanity-wide scale. 3, digital public goods that we have created are increasingly perceived by the world as delivering revolutionary progress. 4, India's experiences can provide insights for possible solutions. 5, our G20 priorities will be shaped by the interests of the global South. 6, we will encourage sustainable and environment-friendly lifestyles based on trusteeship over nature. 7, we will seek to depoliticize the global supply of food, fertilizers, and medical products. And 8, we will encourage an honest conversation among the most powerful countries. So, as the youth of India, it is important that you are not only aware of the G20 activities, but also of India's approach that I have just summarized. Under the Youth 20 Engagement Group of the G20, India will focus on skill development, on the future of work, access to quality health, and youth as equal partners in the development agenda. During the year, in the spirit of Jan Bhagidari, I would encourage the youth to conduct and host a wide range of practical activities like university lectures, roundtable discussions, model UN conferences in colleges on G20 agenda, and welcoming G20 delegations, including through cultural performance at various meeting venues. Remember, each one of you present physically here and virtually across, each one of you is an ambassador of India to the G20. I urge you to collectively be the radiant lotus of creative brilliance and generational optimism. Our success in the G20 will surely draw strength from all of you. And the G20 is in fact the premier grouping which is devoted to addressing the financial, economic and development challenges of the world. And in these difficult times, it is therefore particularly important that world leaders focus on the right issues, issues that especially affect the more vulnerable sections of the world. Now, the attention obviously needs to be given not just to the problems, but equally, perhaps even more so, to finding viable solutions for them. In this regard, India's example is of increasing relevance to the rest of the world. Whether it is our last mile delivery done using digital platforms, a way of responding to the COVID and other public health challenges, or indeed the transformation in green and clean energy that we have seen in the last few years. There are very good reasons why today the world is taking a much deeper interest in us. The G20 presidency offers an opportunity to share our story with others, particularly those who may transpose some of our experiences on their performance or challenges. And it is also a time when we must become the voice of the global South that is otherwise underrepresented in such forums. Countries of Asia, Africa, and Latin America trust India to speak up for them. We have of late been in the forefront of expressing their concerns on fuel, on food, on fertilizers. And we share too the apprehension that sustainable development, climate action, and climate justice could be sidetracked due to more dominant issues. But our task will end not just with articulation. India has to take the lead in pushing for collective action, and that is exactly what we intend to do at the G20. Now, there are established mechanisms and working platforms to take forward various issues that come up in the G20 agenda. But the G20 naturally responds to the pressing issues of the day. It is also a tradition in the presidency, for the presidency, to flag concerns that are most immediate and seek support of the larger membership. Where India is concerned, some of the priorities are self-evident. Energy security and food security are two such examples. After the pandemic, there is a global expectation that more equitable solutions would be found for health challenges. And as the driver of the widely appreciated vaccine Maitri, the global South has hopes that India would take forward this cause. Our commitment to climate action and climate justice is again very well recognized. This is even more so in the context of national actions and policies on this subject in the last 8 years. Most of all, our digital prowess and its effective application on the ground, that has really caught the world's attention. While noting all these developments, let me address some specific issues that are likely to come up in the G20 context. As a civilizational state, it was imperative that India is not only conscious of its heritage and culture, but brings those perspectives to bear on contemporary issues. As we currently consider the challenges of climate action, it is natural that we reassert our innate reverence for nature and search for solutions that are not just material but also behavioral. We would seek to encourage a rethink around the world, both on how we produce, but equally important, on how we consume. Green transition at scale is possible only when climate action is converted into a people's movement. During our G20 presidency, we will spotlight life as in lifestyle for environment, with its associated environmentally sustainable and responsible choices at the level of individual lifestyles as well as national development. Only then will it lead to globally transformative actions, resulting in a cleaner, greener, and bluer future. We will make life a global movement, one that envisions placing the prevalent use and dispose economy with a circular economy. It intends to nudge individuals to undertake simple acts in their everyday life that can contribute to effectively address the challenges of climate change, environment degradation, energy crisis, and rapid sustainable growth. Pro-planet people adopting fundamentally sustainable lifestyles will change the way we do business in the 21st century. India will seek to be a catalyst of that change. When taking over the G20 presidency in Bali, Prime Minister Narendra Modi spoke about a sense of trusteeship. We want that message also to go out from the G20, that for the sake of future generations, for people like you, every generation should leave the planet in a better shape than it inherited it. After due deliberation, we have therefore taken up Vasudhaiva Kutumbakam, or One Earth, One Family, One Future, as our G20 presidency theme. Drawing from our cultural ethos, this is a strong assertion of beliefs in shared and common solutions. It may apply to climate action and life, where the power of example, the diffusion of technology, and the spread of best practices can make a decisive difference. The same drivers are even more powerful when it comes to digital delivery, in order to ensure that we leave no one behind. And remember, we have demonstrated it even at a time of extreme stress by undertaking successfully Vaccine Maitri. The G20 is a diverse platform that seeks to forge common ground on key issues among prominent countries. Our endeavor is to make that consensus more relevant through a wider process of consultation. Indeed, our very choice of guest countries is reflective of this intent. Harmonizing various interests is something that is ingrained deeply in India's history and culture. We have long been a pluralistic and consultative society who have debated issues openly before we arrive at a decision. Since this is deeply ingrained in our DNA, we have never been insecure with diversity. Our essential unity is not only the basis for pluralism, but it is also a source of confidence for engaging the world. As the mother of democracy, India's G20 presidency will be consultative, it will be collaborative, and it will be decisive. Having noted that, we must also recognize that the global order today is not truly reflective of the state of the world. Institutions and practices created 75 years ago still dominate global decision-making. A representative and democratic international order must press for change, not just in the United Nations, but in other international institutions as well. While we strive to progress on this broad agenda of issues, the G20 cannot be impervious to immediate developments that have a direct consequence on global well-being. This year, much of that debate has centered around the Ukraine conflict. As you all know, the Prime Minister had declared that this is not an era of war, and that dialogue and diplomacy alone can provide solutions. At Bali, the significance of this position was widely recognized by G20 leaders. In fact, the universality of this message is being appreciated as well. Many of you today would have read in the newspapers that you would have seen in the morning or read on your phones, Prime Minister's own thoughts about assuming the G20 presidency. And that, by the way, has appeared in newspapers across the world. Now, we should reflect on what, to my mind, were the 8 key points that he has articulated in his speech. And those points are: 1, the greatest challenges can be solved not by fighting with each other, but by acting together. 2, technology gives us the means to address problems on a humanity-wide scale. 3, digital public goods that we have created are increasingly perceived by the world as delivering revolutionary progress. 4, India's experiences can provide insights for possible solutions. 5, our G20 priorities will be shaped by the interests of the Global South. 6, We will encourage sustainable and environment-friendly lifestyles based on trusteeship over nature. 7, we will seek to depoliticize the global supply of food, fertilizers, and medical products. And 8, we will encourage an honest conversation among the most powerful countries. So, as the youth of India, it is important that you are not only aware of the G20 activities, but also of India's approach that I have just summarized. Under the Youth 20 Engagement Group of the G20, India will focus on skill development, on the future of work, access to quality health, and youth as equal partners in the development agenda. During the year, in the spirit of Jan Bhagidari, I would encourage the youth to conduct and host a wide range of practical activities like university lectures, roundtable discussions, model UN conferences in colleges on G20 agenda, and welcoming G20 delegations, including through cultural performance at various meeting venues. Remember, each one of you present physically here and virtually across, each one of you is an ambassador of India to the G20. I urge you to collectively be the radiant lotus of creative brilliance and generational optimism. Our success in the G20 will surely draw strength from all of you. And the G20 is in fact the premier grouping which is devoted to addressing the financial, economic and development challenges of the world. And in these difficult times, it is therefore particularly important that world leaders focus on the right issues that especially affect the more vulnerable sections of the world. Now, the attention obviously needs to be given not just to the problems, but equally, perhaps even more so, to finding viable solutions for them. In this regard, India's example is of increasing relevance to the rest of the world. Whether it is our last mile delivery done using digital platforms, a way of responding to the COVID and other public health challenges, or indeed the transformation in green and clean energy that we have seen in the last few years. There are very good reasons why today the world is taking a much deeper interest in us. The G20 presidency offers an opportunity to share our story with others, particularly those who may transpose some of our experiences on their performance or challenges. And it is also a time when we must become the voice of the global South that is otherwise underrepresented in such forums. Countries of Asia, Africa, and Latin America trust India to speak up for them. We have of late been in the forefront of expressing their concerns on fuel, on food, on fertilizers. And we share too the apprehension that sustainable development, climate action, and climate justice could be sidetracked due to more dominant issues. But our task will end not just with articulation. India has to take the lead in pushing for collective action, and that is exactly what we intend to do at the G20. Now, there are established mechanisms and working platforms to take forward various issues that come up in the G20 agenda. But the G20 naturally responds to the pressing issues of the day. It is also a tradition in the presidency, for the presidency, to flag concerns that are most immediate and seek support of the larger membership. Where India is concerned, some of the priorities are self-evident. Energy security and food security are two such examples. After the pandemic, there is a global expectation that more equitable solutions would be found for health challenges. And as the driver of the widely appreciated vaccine Maitri, the Global South has hopes that India would take forward this cause. Our commitment to climate action and climate justice is again very well recognized. This is even more so in the context of national actions and policies on this subject in the last 8 years. Most of all, our digital prowess and its effective application on the ground, that has really caught the world's attention. While noting all these developments, let me address some specific issues that are likely to come up in the G20 context. As a civilizational state, it was imperative that India is not only conscious of its heritage and culture, but brings those perspectives to bear on contemporary issues. As we currently consider the challenges of climate action, it is natural that we reassert our innate reverence for nature and search for solutions that are not just material but also behavioral. We would seek to encourage a rethink around the world, both on how we produce, but equally important, on how we consume. Green transition at scale is possible only when climate action is converted into a people's movement. During our G20 presidency, we will spotlight life as in lifestyle for environment, with its associated environmentally sustainable and responsible choices at the level of individual lifestyles as well as national development. Only then will it lead to globally transformative actions, resulting in a cleaner, greener, and bluer future. We will make life a global movement, one that envisions placing the prevalent use and dispose economy with a circular economy. It intends to nudge individuals to undertake simple acts in their everyday life that can contribute to effectively address the challenges of climate change, environment degradation, energy crisis, and rapid sustainable growth. Pro-planet people adopting fundamentally sustainable lifestyles will change the way we do business in the 21st century. India will seek to be a catalyst of that change. When taking over the G20 presidency in Bali, Prime Minister Narendra Modi spoke about a sense of trusteeship. We want that message also to go out from the G20, that for the sake of future generations, for people like you, every generation should leave the planet in a better shape than it inherited it. After due deliberation, we have therefore taken up Vasudhaiva Kutumbakam, or One Earth, One Family, One Future, as our G20 presidency theme. Drawing from our cultural ethos, this is a strong assertion of beliefs in shared and common solutions. It may apply to climate action and life, where the power of example, the diffusion of technology, and the spread of best practices can make a decisive difference. The same drivers are even more powerful when it comes to digital delivery, in order to ensure that we leave no one behind. And remember, we have demonstrated it even at a time of extreme stress by undertaking successfully Vaccine Maitri. The G20 is a diverse platform that seeks to forge common ground on key issues among prominent countries. Our endeavor is to make that consensus more relevant through a wider process of consultation. Indeed, our very choice of guest countries is reflective of this intent. Harmonizing various interests is something that is ingrained deeply in India's history and culture. We have long been a pluralistic and consultative society who have debated issues openly before we arrive at a decision. Since this is deeply ingrained